Austin police officer Christopher Taylor. A Travis County judge sentenced him to 2 years in state prison for deadly conduct in connection to the 2019 on-duty shooting death of Mauris DeSilva. We wanted to take some time to talk more about this high-profile case, really in many ways a historic case. And joining me now are Austin attorneys Jessica Wynn and Sam Bassett. Thank you so much for taking the time to really help us understand not only what has happened, but the implications going forward. And Sam, I'll start with you. I mean, the first time believed to be a police officer has ever been convicted of an on-duty shooting and sentenced to prison. What is your reaction as someone who's practiced law in this community for decades?
Well, the last 2 or 3 years have been unprecedented in Travis County history for the number of police officers charged and indicted for police misconduct. And this case has taken a very long road. Started out as a murder case. We had a trial. Then they just proceeded on the deadly conduct charge. Other charges this officer faced. It has been a long road, and then the jury decision was reflective of the long road of the case. The jury deliberated for a long time, and then the sentencing was left to the judge, and clearly I think she thought the maximum or a severe penalty was not warranted.
I want to spend a lot of time kind of breaking down the sentence and why the judge and not the jury. But Jessica, your thoughts, just from a general perspective about this case. I've made the point, because it's so striking to me, about how far this case has traveled from 2019 with the police administration at the time saying that they didn't believe that Officer Taylor violated policies. Now we see him being sent potentially to prison, sentenced to prison.
Right, Tony. I think that this is very reflective of the times. Things are changing. Policies might need to change as well. And so it looks like holding police officers accountable is going to be the new frontier in prosecuting and keeping people in line when they're on duty, or officers on duty.
I want to ask, since you brought it up, about police training. And you know, if you're the new police chief in Austin, Chief Lisa Davis, weeks into your administration, you have a police officer who's been convicted of a crime and sentenced to prison. What are you doing right now to assess the training your officers receive, the real life experience they receive to prevent something like this from happening again?
I think you start with trying to reassure the officers that if they act properly, they're not going to have to face any type of situation like that. That's, on the one hand, you must have to deal with that, the esprit de corps of the officers themselves. And then on the other hand, look at ways to tweak the training. Look at ways to emphasize avoidance of the use of certainly lethal force and near lethal force as much as possible. So I do think Jess is right. This is a new time for policing in our country and in our county.
And Jessica, the policies, I think you're saying, have to meet the moment.
Exactly. I think that for the police chief, she's going to have to look at it both on a macro level and a micro level. She's got to look at policing philosophies. Are they consistent with our community's values? But also specifically look at the micro policies and see how they can better train these officers, especially in this circumstance with a mental health crisis.
And this case really put a microscope on how police officers confront people with mental health issues. I think that's one of the major, of course, underpinnings of the case. I want to get to a decision that was made before the trial even started by Officer Taylor's defense. They requested that should he be convicted, that a judge impose the sentence and not the jury. Sam, first of all, I think a lot of people may not even know that that's an option that defendants have. So can you just talk about that? And then furthermore, the decision by the defense to go to the judge and not the jury.
Sure. In Texas, a defendant has the right to choose judge or jury on sentencing. Now, a defendant doesn't have the sole right to determine judge or jury on guilt innocence. But in this case, the defense decided they wanted the judge to assess sentencing if he was convicted. It's a complicated decision, and you have to look at the judge and the judge's history. You have to do a little bit of guessing into the future as to how the judge or a jury might respond. Obviously, juries are much more unpredictable than judges for the most part, especially on sentencing issues. So oftentimes when we try cases, we say, are we picking a punishment jury or are we picking a guilt-innocence jury? And sometimes we're doing both. But in this case, the defense made a decision after a lot of thought, I'm sure, that the judge, if he was convicted, was the better person to sentence him.
Jessica, I know these are your colleagues in the legal community, but I do just want to ask, your opinion. Was that a strategic misstep, or do you think they knew exactly what they were doing?
So I think they knew what they were doing. I think that they saw the court, Judge Blasey, as somebody that would understand the spectrum of offenses and different facts, and that she would weigh them very fairly. Now, I do think that there was an interesting issue, which was the deadly weapon finding issue.
Right.
And so just to break that down a little further, if they went to the judge for punishment, it was their understanding that the state was not necessarily seeking a deadly weapon finding, so she could potentially give probation as opposed to prison. However, it unfolded in a completely different direction. We found that because the jury found him guilty of an offense that included a deadly weapon, and that as it is indicted that was found to be true, that the judge felt like she was not given any sort of discretion, that the jury had already found the deadly weapon finding, which then would make him ineligible for probation or community supervision.
And I know within the legal community, this has been a topic of conversation for several weeks leading up to what happened today. Sam, is it your opinion that the judge, her hands were tied, essentially? She did not have the flexibility to impose probation or community supervision?
I do think, given the verdict of the jury, she had no choice but to impose the prison sentence. And I think her sentence of 2 years was reflective that perhaps if she could have given the officer probation, maybe she would have.
I know a lot of people who were watching this today and following it closely believed that, okay, Officer Taylor sentenced to prison, we're going to see him be handcuffed by the bailiff in the courtroom and then led, to a back room and like many other defendants every day in Travis County, well, maybe not every day, but quite frequently in Travis County, sent to state prison, and then that didn't happen. So talk to us about what the law says a defendant can do with regard to filing an appeal and being released on bond, Sam.
Anytime in Texas you're sentenced to under 10 years in prison, you're automatically eligible for an appeal bond. So the judge knew that, the lawyers knew that, so that's one reason he wasn't handcuffed. Now, sometimes for show or sometimes for other reasons, a judge might go ahead and have them handcuffed and put into custody briefly, maybe for a day or less, until they actually post an appeal bond. But that's kind of a waste of resources. And so he had a sentence under 10 years, clearly, so he was immediately eligible for an appeal bond.
So what happens next, Jessica? So his appeal will go to the third court, correct?
That is correct. And while he's on bond, it'll be the same exact bond. It was a PR bond that he was originally given. So he will remain on that PR bond throughout the entire course of the appellate process. Once that is exhausted, then he'll have to face his sentence.
So, looking at, frankly, I've covered criminal justice here for many years. I was not familiar with this appeal bond possibility. Most of the cases, frankly, we cover have higher punishment ranges. Is it unusual for a defendant, and I'll just ask both of you, Sam, you first, is it unusual for a defendant sentenced for less than 10 years to immediately file an appeal and get out on bond?
Yes. It's very normal. Even if you're just catching your breath trying to decide if you're going to appeal, I think you immediately declare that you intend to appeal and ask for the appellate bond just so you can decide where you're going from there.
So nothing unique about this?
Nothing unique. And another thing to note is that the state did not oppose the appeal bond. As we talked about earlier, this case has taken a long time to get here. Well, that history actually helped Christopher Taylor in this situation because he was on bond so long and he has been totally compliant with his bond conditions. So that gave both the state, the judge, and the defense that comfort that he would be compliant during the appeals process.
And the appeals process, by the way, can take years to play out, right?
I'd say an average of 1 to 2 years and maybe sometimes longer.
It is Also an important point, and we've talked about this as well, that another officer who responded that day, one of the officers, his name is Carl Cretia, stands indicted on a murder charge. He committed very similar conduct. His actions were very similar to Officer Taylor in that he opened fire on Dr. DeSilva too as they were getting off an elevator in a downtown condo complex. Sam, if you represent Officer Carl Cretia, what are you thinking right now? Are you thinking, I'm going to go to trial and hope a different jury comes to a different decision? Or are you thinking you may knock on the DA's door tomorrow and say, what can we work out?
Some of that is client driven. If the client has said, I'm not pleading guilty to anything, I want to go to trial, then your map is kind of set forth. However, even if the client says that, I'm going to be talking to the district attorney about the possibility of not proceeding on the murder case and proceeding on a lesser charge, just as they did with Mr. Taylor. And I think that probably would be well received. So some of it's client driven, but you have to also always be in conversation with the district attorney, because this case and this outcome is a little bit of a barometer for future cases.
Yeah, Jessica, I'm curious about what you would be doing right now.
I would do exactly what Sam just said, which is continue negotiations, see if there's something on the table that Cretia would be willing to at least consider, but also have a very frank and direct discussion with that officer and tell them, look, this is your life. You've seen it play out. You've gotten the benefit of that. And if you are a risk-averse person, maybe we should start talking about brokering deals and negotiating a non-trial option. But just like Sam said, if this individual is saying that they want their trial, they want their day in court, and they want to be heard, he has a fundamental right to that as well.
So I know you both are attorneys and not politicians, but let's be honest that District Attorney Jose Garza ran on a platform of police accountability, was resoundingly won by a landslide in November last month. I want to just ask you, does the county, does the community see what happened today and with the conviction last month? Do his constituents, do voters see this as a promise kept? Or do they see it as maybe a one-off? I mean, it's noteworthy because the district attorney's office has taken other officers to trial, but has not secured a conviction until this case. Sam, what are your thoughts on that?
Well, it's a mixed bag. I think our community is split on some of these issues. You have a lot of people that are concerned about the exit from the police department and the staffing shortages. On the other hand, you have a vigorous majority, certainly of Democratic voters, who want more police accountability. So this case kind of bore that out. Starts as a murder case, ends up with a lesser charge, and then we have a sentence which is close to the minimum, given that he wasn't eligible for probation. So it's a struggle. It's a struggle for the community, and I think it's a struggle for the electorate to decide how this plays out in their mind. But Mr. Garza has run steadfastly on this principle, and he has stuck to prosecution of police officers, no doubt.
Jessica, your thoughts on that question?
I think Jose Garza's platform from the beginning is substantive change in the criminal justice system. I definitely see this as promises kept, and I do think that this will continue, that police officers will continue to be under a microscope with their behavior and their choices that they make. But I also think that it opens up a larger discussion on what changes can be made and should be made. And I think that that's exactly what Jose Garza was wanting when he ran for office.
One final question I just want to ask both of you, and it's a challenging question, so my apologies in advance. I ask for your forgiveness in advance. Predictions on how this all shakes out, be it months or even years from now, Sam.
Well, it's hard to say if Mr. Taylor will actually spend any time in prison with the appeals process. Will there be any kind of appellate issue that causes a new trial and a new negotiation for probation? And then he has the guy down the street about 5 blocks in the governor's mansion probably paying attention to this as well. Is he going to get involved and issue some sort of a pardon at some point? It's hard to say, but I would be surprised somewhat if Mr. Taylor actually goes to prison and serves a sentence.
Yeah, how about you, Jessica?
I agree. I think that it's I'm not a fortune teller, and
Yeah.
it's going to be a very long road. We thought it was a long road getting here. It's going to be a long road on the back end as well. I will say that I know that more discussions will be had with the department and trying to both boost our morale after all of this has happened, while also really trying to affect change to make policing different now.
But what happened today really is a defining moment for our community, for prosecution of police, and for people working in law enforcement. Jessica Wynn and Sam Bassett, thank you.
Thank you,
so
Tony.
much for joining us and helping us understand all of the complex legal issues at play. Thank you again for joining us.
Thank you.
Welcome.